Proceed.
Good morning, Your Honors, and may it please the court. My name is James Morgan. I represent Mr. Odie Gillespie.
Would you like some rebuttal time at the end?
Yes, please, 5 minutes. And this is appeal from a jury trial that was held last November of 2021, and it was the first trial that I tried where contributory negligence was on the verdict form for the jurors to decide. This case talks about the rear end presumption, and the Byrd case, which was decided in 2012 by the Florida Supreme Court, talked about how unless the presumption is rebutted, the beneficiary of the presumption is entitled to judgment thereon as a matter of law. And we all know that judges decide law, not juries. And they talk about the presumption as it vanishes and loses legal effect when evidence is submitted, not proved, not the greater weight of the evidence, not some determination of whether you don't have to produce uncontroverted evidence, but just any evidence is produced from which a jury could conclude that the real fact is not presumed. And that's language of judicial decisions, not fact-finding decisions by the jury. And our position is that really this presumption should never be considered by the jury. This is a decision that the judge needs to make, and either it's rebutted or it's not, because really if it's not rebutted, there's nothing for the jury.
So your argument, you're focused right now on the jury instruction.
Yes.
So your opponent has pointed out that without a transcript of the charge, we don't have a record sufficient to reverse on that issue. What do you have to say about that?
Well, I think there's a dispute as to what was read to the jury with the instructions that was filed in the court file, the instructions that were actually read.
My question is a little more nuanced than that. We don't have a record of you objecting to the instruction at the time it was given.
So there was the charge conference, which I believe is in the record, where we discussed the jury instructions. I objected at that time. I filed the proper instructions I believe were supposed to be given, and that was in the record. So the charge conference was in the record. I wish I don't have it here, but that was definitely there because I cited my brief where the judge is talking about giving the prior instruction the violation of law, and so it would be in that discussion with the judge. So I did file the charge conference, so I do believe that was there was sufficient record there to reverse on that. So I definitely did. I definitely objected, and I filed the proper instructions, which I believed were supported. And the other problem with the jury instruction, again, is it says
there a later objection when the instructions were either read or right before they were read when they were completed? I mean, I realized that was a charge conference at some point in time during the proceedings. Was there any other objections raised? And if so, how are we to see that in the record if that's not provided?
Okay. Well, I do believe that it was in the charge conference. It was a one-day trial. So we did the jury instructions during, I believe, the lunch break of the one-day trial. So we picked the jury on the Friday and we came back Monday and did the actual proceeding. And it was at that point where we discussed the jury instructions and came up with the final instructions. And I certainly objected at that point to the judge saying this isn't proper to give this instruction. And it was so that should be in there in the charge conference, maybe the supplemental record that was filed. Because I do.
Let's get to the sort of the substance of it. What evidence do you rely on for the proposition the jury was misled or confused by this instruction?
Yes, well, so the first part of it is the violation of law instruction which was given, saying that the appellee here violated Florida law by mixing up the sign. So the sign said stop if there's pedestrians present in the crosswalk, and the rear driver said there was no pedestrians anywhere around the crosswalk, and that the front driver treated that as a stop sign, and which was improper because that's negligence. And so I argued to the judge, I said, well, the problem is you're telling them in the prior instruction that this is evidence of negligence, which rebuts the presumption that the rear driver was solely at fault for the accident. And then the next instruction says, well, before you can consider the prior instruction, I guess, they have to prove at some standard, prove these 4 elements. And I said, but Judge, we're asking them to find that the front driver was negligent. And that is the confusing part, because I had to go, well, I know this says this, ladies and gentlemen of the jury, but look at this instruction. It says something different, that she was negligent. And so it caused this very confusing thing with the jury, especially saying that I have to prove these 4 elements, which I don't think was even for the jury to consider, based on the Berg decision, because again, all I had to do was produce evidence that which much a jury could find. So that's the confusing part of the actual jury instruction there, because it doesn't talk about illegal stops. As we know from the Bonner case, you can show that there was a legal stop, which we said was the violation of the law. That rebuts the presumption. And so that wasn't even given to the jury to consider here in this case. And so then there was another problem with what happened during the trial. It had to do with the fact that the appellee's counsel brought up one of the witnesses was a former defendant in this lawsuit, the one that we're talking about right now. And
that was for the purposes of impeaching and drawing out her presumed potential bias, right?
Yes, it was.
And we did no discussion of any settlement terms or settlement agreement was mentioned, was it?
No, but on the Selby case, Selby, that's a Florida Supreme Court case in 2009. They talk about this, where it should never come into evidence because of the Florida statute 768.041, and it says that it's not to be made known to the jury that a defendant was dismissed from the lawsuit. So what evidence do we have that they were dismissed? He says you were a defendant in this lawsuit. And when the jury gets the style, the person's name's not on there. How would they, that?
Are you giving jurors a lot of credit for reading the style of the case?
Yeah, well, I would say, so here's directly from Selby. Here's exactly what the court said, because it was a conflict case from the fourth and the third DC. It said in both cases, the plaintiff dismissed the defendant from the case and then called the former defendant to testify. In both cases, the trial court permitted the remaining defendant, that would be the appellee in the case, to use evidence of the witness's former party status. That's
so what about the rule of evidence that 90.608 subsection 2 in the case law that shows, that confirms that bias can be shown based on a witness's involvement in the litigation?
Yes, but again, they said that here, that talk about a former party status. That's exactly on Selby, because the fourth DCA said, well, there's an exception to this that allows you to.
Statute doesn't say the former status of a party, because just because the party is not in that lawsuit that's being tried, that party could be tried in a separate proceeding, correct? So a dismissal, just because their name doesn't appear in the verdict form or the case style, doesn't necessarily mean that they were dismissed. I mean, there could be a separate suit going on with that party, that they're not being tried on the same day. So I think you're jumping to a conclusion that isn't necessarily so that it fits within the statute. The statute doesn't talk about the status, it talks about dismissal. And I don't think, maybe you could show me, I don't think there's anything in the record where it was referred to that party being dismissed.
Okay, well, they did talk about, they said you were in this lawsuit, you were sued first, my client was added later. And the status of the defendant, that's the Supreme Court of Florida's talking about.
Shifting to another part of this, again, your opponent argues that the record is insufficient to give you a basis to argue for reversal, in part because, according to your opponent, you've essentially waived this issue by not producing a record showing that you asked for a curative instruction or a mistrial on the line of inquiry concerning Ms. Pelfrey's status. What do you have to say about that?
Well, yeah, so this was a little bit of an unusual trial, because these were videotaped depositions that were done before the actual trial. So she was not in court. There was not this contemporaneous objection. These were all edited out. So these.
But the depo came in at trial and you were there and we don't have a record of it.
No, her testimony is there because it was a videotape.
No, I'm talking about where you might have objected or sought a curative instruction or asked for a mistrial or done something else to preserve an error to raise with us.
Well, I did that because when we went through her videotape deposition, I took out parts of her testimony. Like the judge said, okay, you shouldn't say settlement. And I said, but you shouldn't be talking about her status as a former defendant in this case. And that was in the record there. And I can go look for it, but that was discussed. So there was no point to get up again and object if it was already ruled upon before with the judge before, because again, we had to edit this stuff. So we had to go out and pull out these my objections. Some of them were pulled out, some of them weren't. But the jury was made known this bias. And again, the Saleby says that, evidence of their former status to impeach the witness is in controversion of the statute. So that's what Saleby says. It's right off here. And it says the third district, which the Saleby, which the Supreme Court said was the correct decision, was that held that admission of such evidence is demonstrated witness bias, interest, bias, prejudice. It's all the same. It's all falls into the same category. Impeachment was clear error requiring reversal. And so again, this is straight from the Florida Supreme Court 2009 saying that this is not to come out the former party status to impeach the witness in controversy of a statute. So we think that that's clear here and what was asked of the witness and reversible error. There's no further questions.
May it please the court. Good morning, Mark Painter on behalf of Alexandrina McGonigal. Judge Ulbricht, I think you asked the two key questions for this appeal. Number one deals with the record. And one of the things that I do is, I'm not a trial lawyer, I'm an appellate lawyer. When I have trial counsel approach me about a case, they start telling me about it. And I say, I don't want to hear what you have to say about it. I want to see the record because I want to know only what the court's going to know. I want to see what's in the record. And a lot of what we just heard today is, well, there were these discussions that happened during lunch breaks. There were these other things that occurred. That's not in the record. And this court's limited to the record. My review of this case was limited to the record. That's why I put it in my brief that I don't see a lot of the things that are being argued in the court today. These things aren't there. Your review is limited to what is in the record. There were no objections. We don't have even the entire testimony that occurred during this trial in order to say that a reversible error occurred, even if we were to look at these jury instructions and say, was the jury misled? Was this something that was contrary to the evidence? Was this something that's, confused the jury? We don't even know what the jury heard. We don't have a record of the entire testimony that occurred at trial. So I think based upon that, the court is bound to affirm the trial judge's decision at this point. The second issue, I would say, is when we look at the jury instructions, that is something that was within Judge Nicholas's broad discretion. The jury instructions that were given, again, I'll have to backtrack. There were no objections to them. There's no record that this was something that was objected to that was an issue at trial. But the instruction itself fairly stated the law. They talked about the rear end presumption. We have a situation where this is a person who was driving on Anna Maria Island on the 4th of July in heavy traffic. She testified, I had stop and go traffic. I had hit my brakes multiple times. I was, sitting there looking and I saw a pedestrian approaching a crosswalk. She was in front of a crosswalk. She said, I saw a pedestrian approaching. I hit my brakes. Nobody rebutted that testimony. Even Mr. Otis Showings probably mispronouncing that, said, I wasn't even paying attention, I wasn't looking, I don't know, I don't have any idea if there was a pedestrian there. Miss Pelfrey, who rear-ended her, said, I have no idea if there's a pedestrian there either, I didn't see anything. So we have unrebutted testimony, and Judge Nicholas actually, after the fact, in a gratuitous order that I will admit that was probably improper, said I should have directed a verdict in this case. The evidence was so overwhelming that I should have directed a verdict. So that is the evidence that was in front of the jury.
And you've argued that that order provides a basis for reversal under the tipsy coachman doctrine effectively. Is that, I wasn't sure exactly what you were saying about that.
I mean, probably not. I don't think the order was proper. I don't think that the judge, after the verdict came in, can come back and direct a verdict after the fact. So I don't think so. I think it's just indicative of, given the fact that we don't have a complete record, that we don't know what happened at trial, that is an indication of what the judge saw. And Judge Nicholas said, you know what, after reviewing this entire thing, after seeing this entire trial, I made a mistake. I probably should have directed a verdict. So it's indicative of what happened at trial, given our lack of a record. But no, I don't think that the order was proper in and of itself.
Interesting.
And you know, I hate to cut this short, but unless the court has any other questions, I'm just yield my time.
No penalty for cutting things short.
Thank you.
One, you have your full 5 minutes if you care to use it.
Yes. Looking for the record sites, because again, I apologize for being disjointed. But I believe the charter conference and my objections to the jury instruction will be found in record 319. So in the very end of the record. And these were not just lunchtime discussions. There was a court order there typing everything that was said during these things, and that was the charge conference. I believe to preserve it for appeal, you have to have a charge conference. You have to actually file what you believe the correct instruction was, and that would keep it for appellate review. So 319, that's talking about the jury instructions. And I believe in the 176, that's where we're, I believe, talking about the testimony of Ms. Pelfrey.
So at the end of the day, you don't intend that the instructions do not comport with the law. Am I right about that?
No, I actually do, but they do not comport with the law. Because if you look at the instruction, it just says that we have to prove, and there's no proof, like, so you have to prove where the standards actually just produce evidence. That's a big difference between proving something and just, say, putting on evidence, because Ms. Pelfrey was our evidence. She's the one who said there wasn't a pedestrian. There was no reason for her to stop on that day. It wasn't because there was heavy traffic. There was nothing there. And again, I think the case law, and nobody's ever said this before, but if you look at the standard, it is there evidence sufficient that a jury could find?
Was this a standard jury, like a Florida Supreme Court agreed standard jury instruction, or was this a special instruction?
Oh, this was special. This was not an approved.
Was it derived from a case?
I don't believe so. Because if you, and that was the big problem, is that there's a special instruction. It was not a standard instruction. I provided the standard instruction, which is the greater weight shows that, that the defendant of the appellee was negligent, and you can apportion it and everything like that. This was, we can even consider that, which is a contributory negligence. That's the old, before 1973, before comparative law became the law in Florida, that was how it was. And the purpose of the presumption is to fill a void, because the front driver can't see what happened behind them. Okay, and so it talks about the negligence of the rear driver. It doesn't shield the front driver from any negligence that they may have. And so it makes sense that if the rear driver says, no, you did this wrong, then that front driver can say, I didn't do that. I disagree. And so this is to fill a void of evidence because it's really difficult for the front driver to say what the rear driver did. But again, the rear driver said, this is what the front driver did. She treated this stop for pedestrians, there's no pedestrians, and she treated it like stops. So there was no reason to stop at that intersection. And so that's really how the presumption works. And there's nothing wrong with making the front driver defend if the rear driver says this is what you did. And again, that's why we have the jury. Then the jury decides that, well, is it the rear drivers? Is it what they said, or is it what the front person said? So again, I think that the special instruction was wrong. It didn't even tell them the evidentiary standard to use. Because if you look at the standard one, it says that the greater weight shows. This one just said, prove these 4 elements. And under the Palmer case, there was other mechanisms like a legal stop, an improper stop, which goes back to the violation of law, which the judge granted, because I think that's their case. And that was in my brief. And I cited to that where the defendant didn't want that instruction, or the appellee, and the judge said, no, we'll give it, because that's their contention, that she treated that sign as a stop sign, and it wasn't. It was the one that says, you know, pedestrians in the crosswalk, you must stop. But there wasn't anybody there. And so that's really, and so that's the other big, you know, and Berg talks about this, saying that this presumption doesn't alter Florida law on comparative negligence. It's just there because it's not fair to make the front driver say what they couldn't see behind them happened. But if the rear driver brings forth evidence that what the front driver did something wrong, then it goes to the jury, just like any other case that we've been having here for the past 50 years. And so that's why I said that this was more of a contributory negligence, because that's exactly what this instruction said improperly. So thank you.
Thank you, Mr. Hart. Next case is the fatal holiday, for Lawson Garden. Person representative, this is William Rambam,